The said position was approved by the Honorable Lieutenant Governor on April 4, 2018. Hence, reliance placed by Mr. Mittal would be of no consequence, as rather it shows proper application of mind on the part of the authorities. What is important in that case in hand is that at the time of the death of the petitioner's father, the family received all the financial benefits which government employee is entitled. We have informed that the petitioner's mother also getting family pension of rupees 10,000 per month apart from the ground on which the compassionate appointment was rejected. We are also of the view, given the financial benefits received by the family, the petitioner shall not be entitled to the compassionate appointment. The Supreme Court in the case of Umesh Kumar Nagpal Supra has in paragraph 4 as held under. It is for these reasons that we have not been in a position to appreciate judgments of some of the high courts which have justified and even directed compassionate employment either as a matter of course or in post above classes 3 and 4. We also dismayed to find that the decision of this court in Sushma Gosai versus Union of India 1989 has been misinterpreted to the point of distortion. The decision not justify compassionate employment either as a matter of course or in employment in post above classes 3 and 4. In the present case, the High Court has rightly pointed out that the state government's instructions in question did not justify compassionate employment in class 2 posts. However, it appears from the judgment the state government made at least one exception and provided compassionate employment in class 2 post on the spacious ground that the person connected had technical qualification such as MBBS, BE, BTech, etc. Such exception as pointed out above is illegal since it is contrary to the objection of making exception to the general rule. The only ground which can justify compassionate employment is the perilous condition of the family of the deceased. Neither the qualifications of his dependent nor the post which he held is relevant. It is for this reason that we are unable to understand the following observations of the High Court in the impugned judgment. We are of the view that the extraordinary situations require extraordinary remedies and it is open to the government in real hard cases to deviate from the letter and spirit of the instructions and provide relief in cases where it is so warranted. To hold as a matter of law that the government cannot deviate even minutely from the policy of providing appointment only against class 3 and class 4 posts would be to ignore the reality of life these days. It would be ridiculous to accept that a dependent of a deceased class 1 officer should be offered employment against a class 3 or a class post 4, while we leave it to the government to exercise its direction judiciously in making appointments to class 1 or 2 posts on compassionate ground, yet a word of caution needs to be struck. It is to be noted that such appointment should be ordered in the rarest of rare cases and in very exceptional circumstances. As a matter of fact, He would recommend that the government should frame a policy even for such appointments accordingly. We are of the view that the present petition is devoid of any merit and the same is dismissed.